Good afternoon, everyone, and welcome to another LegalTech Talks. My name's Frances Anderson, and I'm the MD of NetLaw Media. Today, I am thrilled that we'll be hosting a really unique LegalTech Talks, an interview with Professor Richard Susskind, which will be undertaken by Joshua Rozenberg. Let me begin by introducing Joshua, who will in turn introduce the session, and also Richard. So Joshua is Britain's best known commentator on the law. He is the only full-time journalist to have been appointed as the Queen's Counsel. All the honorary skills since the late 19th century have been practitioners or legal academics. He is an honorary master of the bench of Gray's Inn and a non-executive board member of the Law Commission. After taking a law degree at Oxford, he trained as a solicitor, qualifying in 1976, and holds honorary doctorates in law from numerous universities. For more than a decade, he has written a twice-monthly column for the Law Society Gazette. From 2010 to 2016, he wrote a weekly commentary for the Guardian website. He now writes a monthly column for the Critic magazine. In 2020, he launched a new blog and is also the author of Enemies of the People, How Judges Shape Society. Now, before we continue, and I'll hand over to Joshua Rozenberg, I need to run through a little housekeeping for those who've not joined one of our sessions before. This session will last about an hour with questions being brought in live through the session. And what we will do is then bring in questions which you may put through the Q&A or through the chat functions below nearer to the end. So if you'd like to speak with Richard or Joshua or ask them one of the questions, please do use those avenues, but also please do raise your hand and we will look to bring that in and we will monitor it all the way. Now, without further ado, Joshua, it's over to you.
Thank you very much, Frances, and welcome everybody. It's a great pleasure to be here talking to you all and to introduce Professor Richard Suskind. This is his latest book. It's called Online Courts and the Future of Justice, and it just happens to tell you about him here. President of the Society for Computers and the Law, Technology Advisor to the Lord Chief Justice of England and Wales, Chair of the Advisory Board of the Oxford Internet Institute, author of numerous bestsellers, including The End of Lawyers and Tomorrow's Lawyers. Work has been translated into more than 15 languages, and he's been invited to speak in over 50 countries. And in the mid-1980s, he wrote his doctorate at Oxford on the subject of artificial intelligence and the law. Now, we're going to be talking about the future of justice. I don't suppose that a year ago you would have predicted that justice was going to develop in the way it has, certainly over the past 6 months, Richard. But before we go there, I just want to ask how your life has changed over the past 6 months, because you are a consultant, you advise law firms, you advise judges, you advise countries, and you travel around the world. You lecture, you write books, you write articles, and so on. And presumably, since March, you've been working from home, is that right?
That's right. I've been locked down here, in fact, for 23 years, because I've worked for myself for many years. And this, in principle, my study has been my base. The biggest change for me, as I suspect for many of us, is the lack of international travel, because quite a lot of what I used to do was travel here and there, giving talks and meeting with like-minded people, or maybe people who weren't like-minded, but chatting through some of my ideas at conferences and events. So from the beginning of March, that just cratered. What's been fascinating for me, though, is for a couple of months, people said, well, you can come and visit us in October, November. We'll be up and running by then. I don't know why anyone thought that, but that's what people were saying. But after 2 months, I think people recognized that the world had moved on, and what we've seen has been so many online events. And if I'm really honest with you, as regards my speaking, it's a lot easier, more convenient. And I think I reach a wider audience sitting here speaking. So my biggest change has been not traveling, but at the same time, being able to meet far more invitations.
And what about the people that you talk to? What about legal professionals? Because one of the things I want to talk about this afternoon is the future of the profession and the role of legal professionals. I suppose it depends which legal professionals you're talking about, if they're involved in restructuring, bankruptcies, maybe litigation next year, who knows, then, you know, there's work to do. But other lawyers probably are finding a hard time, I suppose, especially those who've invested in vast new office blocks in city centres.
Well, there is that, certainly. I think corporate lawyers who are basically doing big deals all the time have found a real dip in deals, but people involved in insolvency and advisory work and ongoing litigation have been perhaps less affected. As a generality, I would say of the major firms I advise, most are saying that the last 6 months was not nearly as bad in revenue terms than they had feared. Not good, but not the Armageddon that they'd worried about in mid-March. So that's been encouraging. The truth is that while parts of the economy clearly closed down, there's still huge amounts of commercial activity and huge needs for legal and professional advice.
And talking of advice, is there a specific piece of advice that you've been giving to large law firms or others in the legal world? Is there any general advice that you'd like to sort of pass on now that may give comfort to those who are in difficulties, or at least reassurance to them for the future?
I'm not sure how comforting it is, but my general thought is we've been essentially thrown into this huge unscheduled experiment. We're having to use technology and communicate and collaborate and cooperate with one another in ways that a number of us have said was to some extent inevitable, but it's happened in the matter of a couple of months rather than perhaps a decade. And what I urge people to do is, in the spirit of an experiment, gather some data, find out what's working well, what's not working well, so that post-COVID we can industrialize the successes and we can recognize those areas which frankly need traditional face-to-face interaction. I'm very conscious most people are muddling through with ad hoc systems and procedures, so they don't feel particularly strategic. But the strongest businesses will be those who today are managing the short term, the challenge of the crisis, but putting in place people, structures, technologies that will allow them, in the jargon, to hit the ground running when this dreadful phase passes through.
Because things are never going to be the same again, and nor should they be, because we're learning new ways of working.
That's absolutely right. And what clients are saying is, and again, we've known this for some time, is that they've now seen that legal services can be delivered in different ways. And it's not that it's a fundamentally different business model, it's the way that the communication and the delivery of service and the end of the endless meetings, it's all of that. They've seen a new way that legal service can be delivered. And one of the phrases I use is that it turns out that good enough is good enough. It's always been said of some of the great law firms that, not intentionally, but the service is gold-plated. Whereas often the pragmatic in-house lawyer, for example, wants a quick answer, cheap and cheerful, as it were. Now, a lot of the spirit of professional service during this period has been of that sort. And so it's fascinating for me that what we regard often as a conservative profession, the legal profession, the reality is that the profession has been remarkably adaptable and remarkably resourceful when it's needed to be. So at the beginning of March, life was continuing for most law firms, but a month later, organizationally, technologically, operationally, law firms around the world had to change, and most of them did quite successfully. So there's an important lesson here, because I think for those who criticize lawyers and say we'll never change and adapt, the reality is when the platform's burning, they will indeed change and can change.
You had a prediction a long time ago about how lawyers would communicate with their clients. You mentioned it in your book. Just tell us about that, would you?
So the story was, it was in the mid-90s, I'd written a book called The Future of Law, and this was talking about the way in which technology would change the way that lawyers worked. And one of the running themes, and I know it just sounds absurd in this just now, but one of the running themes was email, electronic mail. And I said, and was saying in all my talks, that the dominant way that lawyers and clients would come to communicate in the future would be by email. And officials at the Law Society of England and Wales said I shouldn't be allowed to speak in public, and that I was bringing the legal profession into disrepute by suggesting email would be used in this way. What was quite interesting, that was 96, and you might think, oh, what was everyone thinking? But the following year, 97, Economist ran a series of stories where they invited leading futurists, as it were, to comment on how they thought the world would unfold. And Bill Gates, for whom I've got endless admiration, Bill Gates at the time said, and this is 1997, in the future, most people will have email addresses on their business cards. Now, he was saying that he felt that was worthy of comment in 1997 in The Economist, which just shows you the state we were in 1997. And within 4 or 5 years, of course, technology had changed radically. The other thing that I had said a lot that most in that book that research would be conducted online, and lawyers and judges said to me I didn't understand the cultural and the practical impact and implications of a law library and so forth. So times change, we move on. And I say again that when lawyers need to adapt, they will indeed.
I mean, the whole COVID crisis is an appalling tragedy for people who've been bereaved, people who are ill and so on. But if this had happened 20 years ago, even 10 years ago, it would have been much harder for lawyers and others to cope. It's the availability of electronic communications that have at least enabled life to go on and you and I to carry on doing our work.
That's right. If it happened, I mean, strictly in the early 90s, before the World Wide Web came along, where email was really hardly used anywhere, it's all we had was the telephone, and we didn't really have telephone conferencing systems. It's hard to imagine how people would have coped. But I suppose we would have used the phone, and we would have used couriers, and would have written letters and so forth. But what we've managed to do is continue almost at the same levels of productivity as we did when we were managing to meet in person and collaborate. And in some occasions, and I speak personally here, I think probably more productive. And then part of that, you're not spending time interacting with others. But as you say, without the technology, this crisis would have delivered a very different story indeed. Okay, I should say online shopping. If you think of Amazon, for example, which for many of us, we have our daily consignments. It's become part of our lives. We don't go to shops very often.
Yeah, and the shops are feeling the pinch as a result. Let's talk about the courts, because this is very interesting. Obviously, to some extent, the courts have gone online. And if I were to ask you whether you could have predicted, and your book is The Future of Justice, that the courts would move so quickly to an online model, well, we'll see what you say to that. But I know that you also feel that although the courts have gone online, we haven't yet moved very far down the road that you chart in your book. And I want you to explain that. And I want even to consider whether we might have moved further if the courts hadn't had to cope with the pandemic. So let's start at the beginning. There has been a remarkable acceleration in the court reform programme in England and Wales, which, as you say in your book, leads the world, to enable hearings, at least in civil cases, and at least at the top end, the commercial end, to move online. And that's worked pretty well, hasn't it?
I think it has. If I can just take us a couple of steps backward to think about technology and the impact it has on our world and on law. I always distinguish between automation and transformation. Automation is essentially computerizing, systematizing, streamlining our old ways of working. And the first 60 years of legal technology and court technology have been automation. How can we use technology to allow lawyers and judges to do what they do a bit quicker, cheaper, and more effectively, but not fundamentally changing the process? What you've seen in a lot of other industries, and we're beginning to see in law, and I think will be characteristic of legal and court technology in the 20s, is this move from automation to transformation. That's to say the technology that's being used doesn't support or sustain or, in some sense, improve or streamline our old ways of working. It fundamentally changes. It allows us to deliver the service in a fundamentally new way. Now, my view is that in the crisis, the dominant form of remote courts, that's the generic term that we're using as an alternative to physical court, the dominant form of remote court has been the video hearing. Now, I don't believe dropping a traditional physical hearing into Zoom is a fundamental change. We still get the same individuals involved. We've still got the same cumbersome processes. We're just communicating in a different way. And so there's an argument, while there's been a remarkable uptake of that technology, and I think it is true to say, as you've hinted, that most participants, most of the research shows that lawyers believe that the level of service has been satisfactory, quite impressive, in fact. In fact, for many of them, I think, been rather surprised. But it hasn't been a fundamental change. It's just been a version of what everyone was used to. And so you'll also find, and it's worth commenting, that a number of judges in particular who've not felt confident in using video hearings for whatever reason have used audio hearings, telephone conferencing. And some have worked not badly, but generally most people say it's hard to maintain the gravity of proceedings. It's hard to control who's speaking when. It doesn't feel like an authoritative venue. And so the video hearing has worked as an ad hoc system thrown together in a couple of weeks, has allowed us to keep some form of access to justice, and in turn to preserve, I don't overreact by saying this, to preserve the rule of law. Because it's interesting, in some jurisdictions, they haven't permitted video hearings, and so the courts aren't open at all, which in turn gives the sense of a more lawless society. But whether or not in the long run we'll look back and see this acceleration of video technology as a movement to the kind of transformation in court services that we need if we're genuinely to offer greater access to justice, I doubt. So the problem we face, we've got a number of problems. Problem one is, how do we get through the COVID period, given physical courts are shut? Problem two, how do we deal with the backlog that's inevitably building up? Because even if video hearings are going well, they're not managing to cope with all the hearings we have. And thirdly, in the longer term is, how do we, and this is not a new problem, how do we genuinely offer access to justice? Because 6 months ago, and this is what I was saying in my book, for most practical purposes, for most individuals, the court system was too slow, too costly, too forbidding, unintelligible, and somehow out of step in the digital society. Now that problem, which was, we can broaden it out to the access to justice problem, and as in my book, I quote the OECD, who say that only 46% of people in our world live under the protection of the law. I mean, that is unbelievable in access to justice. And I don't believe we're going to offer greater access to justice by introducing greater armies of lawyers and judges in traditional courtrooms.
Okay, so, well, let's move on to what will replace the traditional courtroom, because let me see if I can sum this up. A traditional courtroom, even a remote courtroom, is everybody, the judge, the lawyers, the witnesses, the parties, not necessarily in the same place. They're not going to be in the same place, but they are there at the same time. Yes. And that's the crucial point.
Yes.
It's extraordinary, really, how traditional this is. I see that when the new legal term starts tomorrow, barristers appearing from home in courts where wigs and gowns are worn, are being told to wear their wig and gown at home, although whether they still wear pajamas or whatever else underneath their wig and gown, we won't. I was going to say remains. I won't speculate. I was going to say it remains to be seen, but that's of course not true. So, traditional court online, remotely, is everybody in the same, there at the same time, but not in the same place. What you want to see is an asynchronous court where people are not in the same place and they're not taking part at the same time.
Yes, I don't need to be here. You've summarized it far better than I could. Actually, what I want, though, and I know my book perhaps doesn't convey that this as well as it should, I want a kind of blended court system where different kinds of hearings use different kinds of techniques. So I'm in no doubt some types of hearings will still need physical hearings. I think we've learned through the COVID period that there are quite a lot of hearings that even I've been surprised at actually can be more effectively done or as well done, and we should probably preserve that. But my interest in the book was to some extent in the different end of the market, as it were, the high volume, lower value disputes where the question of proportionality comes in, that it's disproportionate for many people's legal problems to instruct lawyers and have the day in court, to take the day off. And so the idea of the asynchronous hearing is that essentially people have grievances, they submit their evidence and arguments online and think of it as almost like sending an email. The judge oversees a discussion and debate amongst the parties online, and the judge delivers a response online. But it's asynchronous to the extent that you don't need to take the day off work. You can submit your contributions when it suits you. That might be a weekend and it might be at your kitchen table. And so I also want these systems to be usable by non-lawyers if possible. And this to me dramatically alters the accessibility of the court service. This idea that you can conduct your own litigation, and I talk about all the tools we'll need to help people do so, but the asynchronous nature means you're not trying, as you say, to convene either in a hearing online or in a physical courtroom all the parties, because that's often where a lot of the expense and actually the delay stems from. So it's a very different model.
Well, now this model, has been tried and has been successful in British Columbia and Canada, but it's also, to some extent, been successful so far in England and Wales in the tribunal system. How far have the tribunals of England and Wales managed to go down this road? How far did they before the pandemic, and how much progress do you think, if you're up to date on the information, how much progress have they made since?
I think they've made quite a lot of progress, and one hears in some areas that, in fact, conducting hearings in this way is allowing them to eat into their backlog. They had great support when Sir Ernest Ryder was the head of the tribunal service, and so we've heard of this vision for the tribunals, I think, much earlier than we heard of it for the courts. And to some extent, people would argue this kind of work is better suited to the kind of asynchronous exchange. But I want to stress, I think we're still very much at the foothills. And even in Canada and British Columbia, where the Civil Resolution Tribunal, which is probably the world's leading example of this, it's still confined to some very limited areas of law, but it proves or establishes the concept. And the levels of user satisfaction, the research undertaken across the world in the handful of examples of operational systems is very high indeed, because these systems are designed to be, they're not designed by lawyers for lawyers, they're designed to be convenient for court users. So I think it's also been easier in terms of change, as I understand it, in terms of changing the rules and regulations and procedures governing tribunals internationally to change these. They are more nimble, and they do have higher taken as a totality, they do have higher volumes, as it were, of lower value cases. I'm not immediately thinking, and I'm really not arguing, they could use this technique right across the justice system. That said, what fascinated me when I wrote that book is the feedback from a lot of international arbitrators who were saying that in some of their larger cases, the final hearing may indeed take place physically, although recently it's been by video hearing. But so many of the interim decisions and issues were sorted out or are sorted out in precisely the kind of asynchronous way I'm referring to. And so, although my instinct was that this would be useful for low value cases, in fact, the techniques are already being used in higher value cases. But let me stress again, I don't want to say all cases can be settled in this way, and I certainly don't think serious crime could be sorted out in this way. But what I would like us to explore and have at our disposal is a buffet of possible ways of sorting out legal problems, or the state sorting out legal problems. And since then, I've written quite a long article published in The Practice, which is a Harvard Law School's online publication, where I talk about what I call front ends. And I touch on it in the book, but I think what we've seen springing up is the idea of private sector online dispute resolution. So you don't jump to the court system. There are private sector alternatives. And if they fail, there's perhaps a jump there into the court system. And ideally, we would like there to be some enforcement link. So if there is a decision made by a private sector dispute resolution body, somehow has the bite or the teeth of a court decision as well. So even in the last 6 months, I think my ideas on this have evolved.
Well, how do they fit into the system? Because, I mean, if you arbitrate, then an award under the Arbitration Act can be enforced in the courts, can't it? So is the idea that you would go to one of these private organizations, it presumably acts a bit like an arbitrator, and if the other side won't go along with it, then it could be enforced by the courts? Is that the idea?
Well, in fact, how we'll do it is the subject of a study that's being commissioned by LawTech UK. One of the lead partners is Oxford University there, where we're trying precisely to answer that question. Because in arbitration, as you mentioned, they've got their own legislative provision. And we want something like that, but realize it can't be exactly like that, as I say, allows there to be a linkage to court enforcement, even though a decision is not made within the court. We don't know how that'll work yet, but that's a key question. It's one of the key unanswered questions. A little bit like in a way, the question with alternate ADR, generally mediations and so forth, that the decisions or the conclusions arrived at are not enforceable in the same way as findings and determinations by the courts. So if we can add some teeth, then that would encourage people to comply with these decisions, because there's little point in having online dispute resolution systems whose conclusions people would just ignore once delivered, and then you have to go through the court system as well. So a public-private partnership here is a very interesting concept.
And how are the judges coping with all of this? Because, you used to speak to judges who thought this was all going to be terrible, and they were worried about being put out of a job and they couldn't understand it. And what's their reaction been? I
think like any group of professionals, and we've seen the same in medicine and in audit and in teaching as well. There are some people who came into the crisis who felt that this technology should be used more widely anyway, or technology could be. There's some who were agnostic, but have kept an open mind, and through this process have become quite evangelical. And there's some for whom, as I mentioned earlier, this is out with their comfort zone, are very nervous about this change. But what we have actually it's not just in the judiciary, it's everywhere, is a slightly polarized response to this extent that I think there are those who would say, when the COVID crisis passes, we should just go back to the way we were. Quite a strong school of thought. And then there's another school of thought who say, we should be using this as a platform, a diving board that allows us to spring into the future that many of us felt was inevitable. And you see a division in the judiciary. What we're very lucky in having is particularly a Lord Chief Justice just now and a Chancellor who are very supportive and sympathetic of technological change. And I think we can expect over the next 3 to 5 years, it'll be more of what I call the industrialization, which to say these senior judges will be encouraging other judges to bring the technologies forward post-COVID that work well during this period. But as you can understand, in terms of the age group and the background of the individuals, many judges involved, this is not easy. And what's difficult, and it's quite hard for people in firms to grasp this, is that it's not like having the kind of technical support that you would have in your law firm, where you've got IT specialists on tap. I think a lot of people, and this is not just in the UK, but judges around the world have felt they've really had to climb the learning curve themselves and be rather self-sufficient. But all of this for me has been rather encouraging, because we now, in the end, we now have a body of judges here and around the world who are far more sympathetic and supportive. So that's the platform, it seems to me, that I want to build on my more general idea about online courts.
You talk about the age group. I might just mention that all the judges in the United Kingdom are now younger than me, apart from one who retires this afternoon. So, if I can cope, I'm sure they can too. But I want
Joshua, you still look remarkably youthful. You haven't changed in all the years I've known you. So I find that hard to accept.
Let's talk about artificial intelligence,
yes.
Because some of the judges used to tell you that they were worried that you were trying to replace them with computers. Now, tell us what artificial intelligence can do at the moment, because it can do a lot for law firms, document analysis, all that sort of thing. And tell us what it can't yet do, and it's nowhere near doing in terms of deciding cases.
Yes, the fraught issue of AI. In the 80s, when I did my PhD in AI and law, and then I developed the world's first commercial AI system for lawyers, what we did to build an AI system was you essentially built a huge decision tree, like a huge flow chart. So you took a very complex area of law and you mapped the legislation or case law into a decision tree, and essentially through a kind of interactive question and answer, you allowed other people to wander through a complex area of law. The system I worked on was the Latent Damage Act 1986, a very, very difficult but quite wide-ranging aspect of the law of limitation. And we developed the system at over 2 million paths through it, which allowed non-experts within a few minutes to answer questions that really only a handful of people in the country could have answered. And so that was established in the 80s, using a whole bunch of techniques that are broadly called rule-based expert systems techniques, which allowed us to translate complex areas of law essentially into decision trees and flow charts. And that dominated the AI and law for a period. But you'll know that there's a new form of AI has emerged over the last 10 or 15 years. It was actually around when I was doing my research as well, but it's come to the fore, and that's machine learning. And that is where you don't explicitly program machines, nor do you write flowcharts or decision trees. These systems learn from huge amounts of data. So let me give you an illustration. When you learn a language at school, when I learned French, I essentially was given a list of words and some rules of grammar, and I put them together. In a sense, that was a programming environment. This is a first generation AI system, essentially. This is how you learn the language. You'll have friends, as I did, who disappeared to Paris for the summer and came back speaking fluently. They didn't know the rules of grammar. They couldn't remember learning the words. What they had done was absorbed huge amounts of data, and somehow we seem to have the ability to build on that data in a way that allows us to speak the language fairly fluently. That's the difference between the first generation of AI and the second generation. The first generation explicitly programming, the second generation, these systems learn from huge amounts of data. So you've now got systems using the second generation that can, for example, oversimplification here, but help people when there's millions of documents, help them identify the most relevant documents in dispute, or when there's a due diligence exercise, help them essentially predict the documents that an expert would believe as relevant or worrying out of a large body of documents. Another area which is relevant for your question is the idea of systems that can predict the outcome of disputes. So I want you just to hold that idea. When people say to me, can a machine replace a judge? They can be meaning three things. They mean, first of all, can we develop a system that can think and reason and work like a judge? Now, neuropsychologically and neurophysiologically, we're a million miles from that, so that can be disregarded. Secondly, though, you might be saying, have we got AI to the stage where these systems can produce decisions with reasons? Well, the nearest we came to that was, frankly, the body of work that I and others were working on in the 80s. And these systems are still so primitive that there's no way they would be delivering authoritative binding decisions like a judge. They might help us diagnose legal problems, but they're nowhere near being up to the task of taking on judicial work. But there's a third option, and that is the use of these systems, as I say, to predict the outcome of courts. So I always give Brazil as an example. Brazil has a backlog in its court system of 80 million cases, 80 million. Imagine saying, and I just put this as a thought experiment, this is how AI might work. Imagine saying to two parties in dispute in Brazil, with all the will in the world, your case is never going to be sorted out by lawyers and courts and physical courtrooms. But we have a system that has all the past decisions in your problem area, and it can predict what the court would likely decide. Would you say to the two parties, would you accept the decision of this system as a binding decision of the court if its degree of certainty about its prediction is, say, 95% or higher? And so what I'm pointing out there, I'm not recommending, but I'm just giving us something to debate in the community. We can imagine systems where there is no realistic human alternative, and it is based on past human decisions, offering some kind of route to an AI-based, binding, authoritative, state-based court decision. That is a whole set of arguments, very loosely summarized, but that's what I mean when I think AI could have impact on the judicial system. We're probably a decade away from that being technically feasible at scale, but we can see it coming.
Okay, well, look, we're going to move on to questions fairly soon. Just to encourage people to answer questions, I'm going to read one out now. It's from Neela Ramanathan. And Neela Ramanathan says, we're becoming familiar with how legal tech helps in the delivery of legal services. How do you see technology helping in the transformation of the business of law? So a very open question about technology.
Well, that's a very interesting question, because if you have a look at the legal tech world and how much money is spent there, about $30 billion internationally. And incidentally, compare that, that's in a $1 trillion global legal market. Compare that to other sectors, and we're spending a tiny amount in technology. That's why I and others predict private equity, venture capital, other areas coming in. But the truth is, the dominant use of technology so far in the legal market in terms of pounds spent have been in the back office. It's been laptops, it's been licenses for accounting system, word processing. It's been the teams of people who keep the systems robust and secure. Without email accounting and word processing, any law firm would fail within days. You need a whole set of people, technologies, infrastructure support that. And that has been about 90% of the legal spend, of the spend in the legal technology industry has been in the back office. What we're now seeing is a movement towards using technology in the delivery of services to clients. And that can happen in two broad ways. One is, and this has been the COVID technology, we can find new ways of collaborating, coordinating, collaborating, communicating with clients. That isn't a meeting, it isn't a phone call. We can find new and exciting ways of reaching out and exchanging documents, ideas, and so forth with our clients. And you look at other industries, for example, who don't use email nearly as much, they use software like Slack. There are different ways out there that we can communicate. You see the idea of online deal rooms, you see the idea of online project management and so forth. You've seen, and we're experiencing it today, advanced video technology as well. So I summarize that by saying that's changing the client experience. It's changing the way that the client receives legal service. Not really changing the one-to-one consultative advisory model, which is how lawyers work. That's the second big change, where legal advice, legal content, materials, and documents are available online as a form of online service. So if people want to know their rights and obligations, if they want to draft documents, if they want to predict the outcome of disputes and so forth, that's available as some kind of online service. More than that, we'll be developing legal content, legal systems that will embed within our financial institutions, our manufacturing companies. The law will become almost modular and Lego-like and plugged in to broader information systems. The big move, therefore, is technology out of the back office into client service, A, changing the client experience, and B, changing the very way we deliver service.
It's very interesting because I'm not familiar with Slack. You could just tell me in a word what that is. But I mean, what I imagine you're talking about is, I'm here at my screen, and on my screen, you're talking to me in video, you're putting up documents on the screen, just as I can see questions on Zoom at the moment. You're showing me some animation, you're bringing in other people from other places, you're I don't know what else you're bringing, but everything is coming together on a screen. Do I, as the client, need to be pretty high tech to cope with this? Are most business people able to cope with this, or is that going too far, and what people really want is the friendly fireside chat?
Well, this is, in a sense, the big question. If you're the law firm, or maybe the big four firm, that provide these kind of online shared spaces that allow people to work more conveniently, if there's some providers who make that available to clients in a way that's intuitive and fun to use, and they say, wow, I just never knew this could be so easy and straightforward. That's what I'm talking about, the user experience. I think just now these systems and these services are not quite as easy as Amazon, as it were. But the law firm or the professional provider that makes it as easy as Amazon, that makes the reception of legal service easier, more intuitive, more instinctive, less forbidding, and so forth, that's a huge differentiation in the marketplace. I would say if you need to climb a steep learning curve as a client to use these technologies, then you've probably failed at the first hurdle.
Okay, I've got quite a specific question from Karen Ray. And Karen Ray says this: in the civil courts in the UK, we've got through work since June remotely. But is there any way round what is considered a necessary live face-to-face hearing? And Karen Ray is talking about the possession lists, housing repossessions soon to commence in the UK courts. Karen Ray says a duty solicitor is required to advise the often disadvantaged defendant who may have been fearful for eviction for many months and who may not have the technology to participate in remote hearings. So is this what you were talking about when you were saying that technology isn't necessarily suitable for all hearings and some have to be dealt with in a traditional way?
That's absolutely right. And my slight naivety in first thinking about this was thinking, okay, low value cases, we can do online. Big ticket cases, we still need the court system for. And then you find that actually lots of people involved with low value cases have maybe quite thorny legal problems. Just because it's low value doesn't mean it's not a difficult legal issue. And Some, but I don't think many, but some don't have access to the technology or aren't sufficiently confident to use the technology. And the reality is, if you look at the Civil Resolution Tribunal in Canada, one of the reasons it's so successful is it has a whole bundle of tools to help non-lawyers navigate their way through the law, to understand their rights and entitlements, to help them organize and structure their thinking and so forth. Simply having a video hearing doesn't help people who don't understand the law, their entitlements, to work through the issues. They'll still need legal help in one way or another. So I think if you look at that particular category of case, we don't have, and we haven't invested in the full range of support services that are needed to go online fully in the way I'm anticipating. And so I expect just now, it's almost a case management decision. When, in the interest of the parties, can we comfortably conduct this hearing electronically in a variety of ways? And when, because of the state of knowledge of the individual or the degree of literacy of the individual or the complexity of the issue involved, or perhaps because there's issues of credibility which are better dealt with in face-to-face, when is it better that we convene? And this is, I believe, going to be a running theme through the 20s, that a key case management responsibility of the judge will be to identify those kinds of cases that are well suited for online treatment and those that aren't. And there won't be any simple algorithm that will allocate it to one track or another. We'll feel our way. And some judges, of course, will probably take a different approach. They'll be tougher in saying, look, unless there's a very strong reason to the contrary, I want this online. And others will be perhaps less confident themselves and therefore more inclined to revert to the physical hearing. So through the 20s, we'll be in this transitional phase where I suspect it'll be a weird hodgepodge and mix. But as we come later in the decade, more people will be online, more judges will be confident, the technology will advance, the support systems will be there. And I think it'll be unusual for low value cases for us to conduct them in person. So we're at the foothills and really very much at the beginning of something that's very difficult.
You mentioned investment in the court system, and we know that some of the courts, the physical courts, are in a sorry state. We also know that the government is investing £1 billion in the court reform process, the process of digitizing the courts. A question from Mike Commons on this. What advice would you provide to court systems themselves, the people who set up systems in court, to facilitate the transformation from low tech through the COVID-19 tech court, the courts we're seeing at the moment, to the post-pandemic tech court systems? In other words, what do the courts need to do to prepare for the future after the pandemic?
Well, as I hinted earlier about the three challenges, I think we've got to plan in three phases, and there are three distinct plans. One is we need a group of people on individuals and resources allocated to getting us through the pandemic, to making sure we can keep as many courts open and as much court service available as possible through this difficult time. Secondly, we're not unusual in having a major reform program ongoing. We need a second project, which is going to assess the extent to which the current reform program needs to be adapted or changed in light of the experience. Because I'm saying we've had this massive experiment going in light of the experience of the COVID period. And thrown into that is this industrialization that I mentioned. What parts of COVID technology should we keep for the medium term to help us with the backlog? But there is a third long-term project, and it's the easy one to ignore, which is actually starting with a blank sheet of paper. And this is the long-term strategic project, which should be asking questions like, what should our court system look like in 2030? So I say it's vision-based rather than legacy-based. Legacy-based strategic planning is walking backwards into the future. You're contained and constrained by where you are today. But at some stage, you need to say, well, forget where we are today. And everyone does this in business. Where would we like to be? It's perhaps not a blueprint, but what's the point in the horizon to which we're moving? And if we can find that attractive, we then say, how do we get there from here? And what plans and processes and technology investment? And I still think this is a 1 decade project. The transformation project is a decade. People say, well, we've transformed in 2 weeks. We really haven't. We've as I say, drop trials into Zoom. So we need planning, different teams, resources allocated in 3 different timeframes. If we don't do that, and the inclination of almost all governments and court services that I meet around the world is to say, well, let's put the more distant stuff, that's pie in the sky, we'll put that in back burner. We've done that for decades in this country. In the mid-90s, when I was advising Lord Woolf and I said it's a 10-year view, everyone said that's too long. I can give you 15 or so projects I've worked on where people say 10 years is too long. 2010 doesn't sound too long ago for me. And so 2030, we should, once and for all. The issue is this, it's hard to change the wheel in a moving car. And the answer to the question, how do you do this, is you start a new car. And essentially, we need from the ground up to design and reconceive what public court service will look like, and will spill over from our medium and short-term systems into that new model. Otherwise,
let's have a go at that, Richard. I mean, let's build our new model car. I mean, we've still got businesses. We've still got disputes between businesses. We've still got people in 10 years' time, I don't know, building buildings and then becoming insolvent and not being able to pay the builders, or tenants not being able to pay the rent. We've got the same problems, presumably. And what people want is ideally a system which means that everybody will keep to their word and that they will resolve their problems, ideally without the need for compulsion. But in the real world, even in 10 years' time, we will need some sort of enforcement system. So we've broadly got the same problems, haven't we, in 10 years' time? And how would you sketch out the solutions to those same problems without the need to issue claim forms even electronically and have court hearings and all the panoply of the law that we rely on now to deliver justice?
I think one of the key questions is actually what problems will people have in 10 years' time? But I think where human beings come together, we find ourselves in conflict. So the nature of the people will be having conflicts over issues that we cannot conceive today. They'll be having conflicts over businesses and over technologies that don't yet exist. But I think we can conceive that people will come, that the law of contract will subsist, and that we'll owe duties of care to one another, and that people will be in breach of the criminal law. So I think the broad categories can hold. What I think we need to do is identify, in fairly generic terms, the mechanisms that we think from a user's point of view. So it's a huge design thinking program. See, from the point of view of the users in particular sectors and industries, what would feel like an appropriate, proportionate way of resolving disputes. And that might be done sector by sector. But what I'm sure we don't do is, you were at the meeting as I was, Joshua, when the previous Master of the Rolls says, he said any system that's got a 2,000-page user manual has got a problem. He was referring to the civil justice system of England and Wales and the White Book. And what a lot of people are saying now, what we need to do is simplify the White Book. I think if you're taking a 10-year view, no piece of user design would say what we want is a slimmed down version of the White Book. People say we want very simple rules, and we want most of them embedded and hidden within the processes themselves. And so that's the kind of thinking backwards we need to do. It's a very interesting question, though, whether or not we do it by legal category, as I've mentioned, or whether or not we do it by sector. So we say there'll be consumer problems, there'll be business problems. Maybe we cut the cake in different ways. I'm yet to be involved in that project because no one's yet taken it on, but I'm absolutely sure, having seen similar programs in the private sector in major and very successful companies, that you start with that blank sheet of paper at this stage of doing long-term strategic thinking, rather than how do we reduce the number of pages of the White Book, or how do we get people out of court buildings into Zoom meetings. That's not the thinking.
Okay. Well, let me try some more difficult problems, because you're quite right to say that my questions are based on 2020 rather than 2030. Let's look at the problems ahead, and I'm not saying that these are necessarily going to be solved by courts. They probably require legislation. They probably require government intervention. But let's look at the insurance industry. You've got a problem facing the courts at the moment, and there's litigation being fast-tracked through, arising from the pandemic. And it all boils down to, have I successfully insured against something that nobody foresaw? And the insurance industry said, well, we excluded something you couldn't have thought of. And the clients say, well, that's the whole point of insurance. And that's fine, and the courts have to find a way through it. But ultimately, they have to find a way through it which keeps the insurance industry working, and doesn't mean that the insurance industry is going to collapse, because everybody is expecting the insurers to pay out for all the losses that people are suffering from COVID. So that's one problem. Another related problem, and we've already spoken about possession cases, is leasehold flats, which people have taken. I'm talking about first-time homeowners, for example, and which they can't sell. They can't sell their leasehold flats. They can't because they've gone down in value. And maybe they've gone down in value because they've got cladding, and the cladding means that they're uninsurable and they're unsaleable and so on. So you've got these very endemic problems looming in society. And you've got a justice system that's going to have to cope with this. Or do you simply say, these are matters for Parliament? Parliament has to, work out some way of saving people the money. Parliament has to inject much money into it, as it has done through the government over the past 6 months. These are not problems that the law can sort out.
Well, in some areas, we may, as has been said before, it may be that the judges shouldn't tread into some areas which involve major policy. But if you take insurance, I accept there are some thorny difficulties, some major decisions that need to be made that will actually have a huge effect right across many people's lives. And I'm not for a second saying that these very difficult issues of insurance law should now be sorted out by some kind of asynchronous hearing in the kitchen table. What we do need is, I think, fast, effective ways of senior judges deciding very difficult points of law that have great implication. And then we need mechanisms by which, once the law is clear, a lot of the implications of that decision can actually be, if not reduced to process, then really we can have mechanisms that allow us to dispose in fairly high volumes fairly efficiently. So if you look at the insurance industry, what so many people try to avoid is it's not, they want not dispute resolution, they want what I call dispute containment. That's to say, there's a claims handling function, but insurance companies don't want every disagreement going into a major legal dispute. They design their claims handling in a way that's often driven by data, which allows them to make decisions as to which claims, for example, should be accepted without dispute, where there should be a certain level of dispute, and where it's worth taking it forward. And so I think the whole insurance industry will evolve a whole set of, and they're already in place, but of online dispute resolution mechanisms which will sit beyond the court system. So the court will establish the framework and the law that governs these decisions, and it'll be up to any insurance company that has massive amounts of claims to have in place processes that allow these claims to be dealt with expeditiously. And I think it's the same with landlord and tenants. Once there's clarity in the law, wouldn't it be wonderful if individual tenants without knowledge of the law can, through a fairly simple process, understand and then enforce their entitlements? That of itself would, of course, change the behavior of landlords. If landlords knew that it was easier for tenants, not all landlords, but perhaps mischievous landlords who are inclined to take advantage of tenants who are not familiar with the law, if they knew that the tenants very quickly could understand and enforce their entitlements, that would probably alter their behavior as well. So the availability of better, swifter, easier dispute resolution, both in claims handling and I think in relation to landlord and tenant disputes, will, I think, change the behavior of the community. And that's another aspect that I discuss in my book of online courts and the future of justice, that a system that's more accessible is a system that actually will encourage greater compliance at all levels.
Okay, I want to get in a couple more questions before we finish, but I mean, just talking about possession cases, Karen Ray is suggesting that if you were to bring back law centres with remote technology, you could then perhaps have people who come into a booth where they would be able to type in a question, and there may be somebody at the other end, or it may be a machine that would begin to answer this. And this may be a way of resolving the problem by opening up areas that people can walk into and get legal help, but provided more cheaply than law centres.
I think that's a great idea. I think, and Karen's right, I think we probably need to reconceptualize our voluntary sector, all the wonderful help that so many people give in up and down the country in law centres and citizen advice and so forth. It seems to me that and I know these processes are already their processes are already being modernised, but I think we have to be very conscious as we're redesigning our court system that we actually have that we do so in a way that the voluntary sector will plug in neatly. But Karen's conception is pretty much mine for those people who can't undertake this kind of activity themselves, that there will be a user-friendly voluntary service, someone who can sit by your side and work through the system with you.
And what about redesigning lawyers? There's a question from Angel Sumano in Mexico City. I apologize if I haven't got the name quite right. Do you think that one way to transform the mindset of the legal industry would be to create pilot tests in universities where curricula are mixed between law, engineering, and design? So the idea is that a law student would not just study law, but would study wider issues, engineering, design. I'm not sure if they're talking about the sort of work you did when you were doing your artificial intelligence DPhil at Oxford, because that involved a certain amount of design from an intellectual point of view. But the idea is that if lawyers knew more than law, then they would be better lawyers.
Well, I think it's a really good question, because for me, the fundamental issue that faces any law school is, what are we training our young lawyers to become? Now, if we're training them to be one-to-one, face-to-face consultative advisory providers in the grand tradition, then what we do at law school, one can say, is broadly fit for purpose. But if you accept my view that increasingly we'll be developing systems that will be replacing our old ways of working, I argue that tomorrow's lawyers are people who will be developing these systems. And people want to say, well, hang on, that's not what a lawyer does. But I want to define a lawyer in terms of the help they offer, rather than the techniques that might have been in place for a couple of 100 years. And so the observation from Mexico, I think, is a good one, that if you accept that a key job for tomorrow's lawyers is to design these systems that replace our old ways of working, then wouldn't it be great if people emerge from law school with experience of design thinking, with experience of knowledge engineering and so forth? So I think the point's well made.
Okay, last question is a quote from your book, which has been referred to by Supini Pereira, and it's about the 2020s. You say the 2020s will be a period of redeployment rather than unemployment. Lawyers and judges will undertake different work and work differently, not least in online courts. Now, Supini Pereira wonders whether you saw COVID coming down the road, because we've all worked very differently this year. But last question, looking to the future, what actually is the future of justice?
Well, I have no sense of the horrors around us, but that quotation is really referring to the point I previously made, that those who say lawyers will be unemployed in the future may be right if lawyers insist on carrying on delivering services in the way they have done. But if I'm also right that tomorrow's lawyers are people who help design the systems that are solving people's problems, then I believe the challenge is to redeploy, is to retrain our current population of lawyers so they can engage in the design and development of systems, but also in relation to online courts, the whole area, for example, of although I like the idea of online courts being accessible to people without lawyers, I do accept there's going to be a whole new set of skills required in more complex cases, where it won't be the same as delivering a soaring oral argument. If it's an asynchronous non-oral hearing, then the finest lawyers will be those who know how best to grab the attention of the online judge and convince them of an argument in a pithy way with a certain kind of structure. We'll need a whole set of different skills. Strangely enough, there's still skills of persuasion. You've still got to be logical. You've still got to be rooted in the law. I believe, as with any great argument, it's got to resonate at some emotional level. But the emphasis on oral argument will probably be displaced by the emphasis either of presentation online, which I believe is at least, as I've said, is not the whole story, or for its asynchronous hearing, presentation of arguments in written form, essentially written submissions. So that's a new set of skills. The finest oral advocates today may be less qualified than some people emerging from law school who for a year or so have been playing in labs with the idea of online courts.
And one of those skills is timing, and we have reached the end of our hour. Richard, thank you so much. It's been absolutely fascinating. I've enjoyed it a very great deal. Thank you also to everybody for joining this session with LegalTech Talks, produced by Net Law Media. It's been a great pleasure to do this. I've not done one before, but I've enjoyed it a great deal. The next LegalTech Talk will be on the 15th of October at 3 o'clock UK time, where the topic will be Secure Innovation, Protecting the Digital Shift. It'll be chaired by Janet Day with panelists from Ashurst, DAC Beechcroft, Stevenson Harwood and Egress. Thank you again, Richard. Thank you to you out there for joining us all. And don't forget to subscribe, and you can then join in discussions in the future. Goodbye.